If you're a lawyer in the state of Georgia, or maybe you're just an individual who has a case coming up and you want to know the best way to approach jury selection, I'm a litigator with 15 years of experience and I'm going to share my secrets for jury selection. So stay tuned. My name is Michael Coker. I'm a personal injury lawyer in Lawrenceville, Georgia, and I'm not your typical personal injury lawyer. I don't do high volume cases. I don't advertise on TV. I'm a litigator. My office, as we sit here today, is less than 1 block away from the county courthouse that I spend the majority of my time at. And one of the things that bothers me is how many lawyers don't understand jury selection and the best way to handle the process and to pick the best jury for your clients. And the first thing is you need to understand how jury selection works. I have many attorneys, maybe you've never tried a case, or maybe you just are not a litigator, and you find yourself in a situation where you need to pick a jury. Well, how jury selection works is the individual county will call in a certain number of jurors. Now, the number that they call in is going to depend based on a few factors. One, maybe how many people they expect to be struck for a cause or struck for some reason that they're unable to serve. Or two, how controversial the case is, right? I mean, if you have a case that's maybe been the focus of a lot of media coverage, and so a lot of people already have prejudged the case or have an opinion, they're going to need to call in more jurors to make sure that those people are excused from jury service. Or maybe it deals with an insurance company that many people already have. Maybe many people in the county have this certain insurance company, and so they obviously cannot serve on that jury as well because they might have a financial interest in the case and not even know it because they're a policyholder. And so how many jurors the county clerk calls is going to depend on those factors related to your case. But in most cases, they'll call anywhere between 30 to 36 jurors is what's typical. And so what'll happen is you'll go into the courtroom, those jurors will come to the courtroom, and both sides will be seated at the table. Now, in many jurisdictions or many courtrooms, they'll ask the attorneys to face the jury. So you kind of swing your chairs around, face the jury, basically looking at them instead with the judge to your back. The judge will come in first, will ask some questions, and will ultimately determine some qualifying questions. Things like, do you still live in the county? Things like, are you a felon, right? Because there's certain qualifiers that say whether you can and cannot serve. The other thing is whether or not they're related by blood or marriage to any of the parties, right? You can't have somebody who's related to the plaintiff, for example, or the defendant serve on that jury. But most of what the judge will ask will be very simple qualifying questions, and the heavy lift is really up to the attorneys to determine whether or not that juror is biased against your client or against the other party. And so after that, typically the plaintiff or the prosecution goes first. I should say this. This is predominantly for civil cases. In criminal cases, often the jury will come in panels, and they'll ask questions of individual panels. In most civil cases, they will just bring in all the jurors in the same room at the same time. And so the plaintiff will go first, will ask questions, we'll talk about, do you know anyone in the courtroom? Does anyone have an opinion on whether there's too many lawsuits? Has anyone suffered from this particular medical ailment? And all of those questions need to kind of be tailored to your case, right? And the magical thing you want to know is whether or not that individual has any bias. And so if you have somebody that says, for example, let's say you're the plaintiff's lawyer, and you have someone who says, hey, I think there's too many lawsuits. I don't think that people who come into court should get money. Well, the magical question you need to ask that person, the follow-up question you need to ask is whether or not they can put that aside and be fair and impartial in this particular case. And if they say, yes, they can, then they're basically qualified. They still can serve. But if they say no, if they say they can't be fair, then you need to make what's called a motion for cause to the judge and say that individual needs to be removed from the jury. And typically you do that right during or at the end of your questioning. Now, questioning typically follows two formats. Some judges like for both parties to ask general questions first, like, how many of you have ever been in a car accident? And then the jurors will raise their hand or a number, and then you'll write down all their names or numbers. Then you'll go to your next question. General question. How many of you have ever had surgery before? Paddles go up, hands go up. That's called general questions. Now, some judges have both parties ask general questions and then allow the lawyers to follow up with individual questions. So they'll start with juror number 1, for example, and say, okay, plaintiff's lawyer, do you have any questions for juror number 1? Defendant's lawyer, do you have any questions for juror number 1? No? Okay, then we'll move on to juror number 2, and you go through each of the individuals. Now, other judges like you to follow up immediately during general questions. So you might ask, has anyone here ever had surgery? Juror number 5 raises their paddle. So your then responsibility is to then ask at that point, juror number 5, can you tell me a little bit about your back surgery? Well, I had back surgery in 2013 and I whatever. Oh, okay. Well, you had back surgery in 2013. Was that a painful experience? Yes, it was. And kind of ask any follow-up questions you may have. Again, you need to clarify with your judge what their preference is in jury selection, because what you don't want to happen is ask all your general questions and then assume you have the ability to follow up individually, and the judge wants you to follow up individually at that point. You might have just waived your right to ask them any follow-up questions. So always confirm with your judge what their specific preference is, whether it's everyone does general and then everyone afterward does individual questions, or whether you do general questions and follow up with individuals throughout the general questions. Once you have all those individuals and you've made any challenges for cause that you might have, meaning you've basically said, hey, juror number 5 has said they cannot be fair and impartial because of blank, and you need to be able to support that argument to the judge. You need to say that they need to be struck for cause because they have indicated some bias to you that they are not willing to put aside. Now, I'll tell you this, we all have biases, right? I mean, everybody has biases. So just having a bias is not grounds for cause to strike for cause. But what is grounds for strike for cause is someone who has stated that their bias is so deep that they cannot be fair and impartial to both parties. Okay, that means they need to be struck for cause. Once all the questioning is done of all the jurors, in most civil cases, there'll be a list of the jurors, and they'll take out all the individuals that were struck for cause, and then typically, in most cases, they'll take the top 24 or the first 24 people that remain, and those will be the pool that you'll choose from. And so they'll start with the plaintiff, and the plaintiff will strike one individual. Then the sheet will go to the defense, and they'll strike one. So really, you're not picking your jury. You're taking away the jurors that you don't want. And this will go back and forth, and each side will get 6 strikes. That's why we call it striking a jury, because you go through and actually on the sheet of paper, you scratch out the ones that you no longer have. And usually in my cases, you notate like P1, P2, or D1, D2 for which ones you struck so the judge can and the clerk can track who it was. Once you've struck from those first 24, you have 12 remaining. Sometimes there's an alternate. So then you would take the next 3 on the list, and then you would strike, plaintiff would strike 1, defense would strike 1, and that individual would be your alternate. And you would continue that process for as many alternates as you may have. And so, again, what ends up happening is the plaintiff, you start with a list of 24 remaining people, the plaintiff strikes 6, the defense strikes 6, and you're left with your 12 jurors. Now, from a strategy standpoint, what should you do as far as jury selection goes? And the answer is it depends on the type of case that you have and who you represent. But the best strategy, in my opinion, is to try to get the jurors talking. The more you can get the jurors talking and feeling comfortable with you and giving up information, the more likely they are to kind of give a little nugget or a little piece of information that lets you know they probably are not a juror that you want on your specific case. And so the worst lawyers in jury selection are the ones that have the pre-done questions, they go through their list and they sit down, right? The best lawyers are the ones that listen, that sit there and say, okay, Mr. Smith, you told me that you had had back surgery. Can you tell me what type of back surgery? Can you talk about the effect that that back surgery had on your family? Can you tell me a little bit about whether or not you were able to drive from that back surgery? Can you talk a little bit about how that back surgery affected you mentally? Because the more you get that juror talking and explaining, 2 things happen. one, you learn more about that juror. And two, you start to share with the other jurors the effects that that injury had on that individual. And so you almost allow the jury to hear testimony before the case even begins. And so by taking these jurors down these rabbit holes with questions, you're accomplishing those two things. One, you're figuring out more information. And two, you're locking in the rest of the jury pool to understand the effects of that particular condition. So that's my tips for jury selection. Kind of gives you an overview of what to expect, and then kind of talks a little bit about maybe one or two things that you can do to increase your skills as a jury selection expert. As far as what jurors to keep and not, that's up to you. It's so hard to read jurors. It's hard to know exactly which ones to keep and which ones to take away. But I would always involve your client in that process. The last thing you're going to want is that client telling you, I wanted you to strike number 13 and you struck number 15. You want that client involved in that process, understanding why you do the strikes and which individuals, and even providing input. They may give you information that even you missed, right? They may say, yeah, juror number 6 has really given me, a weird look. We need to strike juror number 6. And that piece of information could be the difference between you winning or losing your case. And so listen to your clients, involve them in the process, and jury selection, you just continue to get better the more and more that you do it. If you have any questions, or if I can help you with anything with your case or jury selection, obviously give me a call. I'm more than happy to talk about it. But if you like getting these updates or learning more about how to be a better lawyer or learning more about Georgia law, obviously like and subscribe to this podcast. I'll keep these coming out. This is my service of sharing the information that I have with the public, sharing it with other lawyers so that we can all be better and serve our clients better. So until next time, thanks for listening.